Folks, the big six disability planning that we're going to learn about here today are just not elder law tools for your elder law toolbox, folks, but I refer to these as power tools. Yes, you heard it right. These guys are power tools designed to avoid guardianships and conservatorships, the messes and stresses of probate court, the economic and emotional headaches of probate court, folks. Because when you do not have the big six disability planning in place, when you do not have enhanced elder law protections in place, and when you or your loved one became completely incapacitated, legally, people cannot step into your shoes and manage your medical affairs. They cannot get access to your medical records. They may not be able to move you from one medical facility to the other, hospital to the nursing home or rehab, whatever it may be. We've seen cases like that. And they will not be able to manage your finances. They cannot touch your assets. They cannot access your bank accounts to pay your bills. And their only choice at that juncture is to petition a good judge at the probate court, which is a very formal process and a very expensive process as well. But pull up the chair, get your notebook out, your favorite beverage out right here. Got my green tea right here, folks. And let's learn, okay? Folks, big six disability planning. Let's talk about that, right? And again, folks, this is the belts and suspenders of your comprehensive trust-centered estate plan. These are power tools to get into your estate plan. Starting first, number one of the big six disability planning is durable power of attorney. Let's talk about that. So, folks, you need to create your durable power of attorney with an experienced elder law attorney is my recommendation, especially if you're 60 or over. And this durable power of attorney is a legal instrument, and a power of attorney could be created, a limited power of attorney or a general power of attorney, or what they call a springing power of attorney, meaning that it's not in effect day one when you sign that, okay? So, folks, my recommendation for folks, most of the time, and everyone's situation is different, your durable power of attorney ought to be to give your agent, or the legal terminology, your attorney in fact, the maximum amount of powers. If it's your spouse, we'll say Bill and Mary. Bill's appointed Mary as his attorney in fact. So Bill and Mary, Bill and Mary, married couple, staying married couple, and Bill's going to appoint Mary as his attorney in fact. So they're going to appoint each other, okay, as AIF, which is legal terminology for your power of attorney agent, but here in the Commonwealth we refer to it as attorney in fact, where they can legally step into your shoes and manage your financial affairs for you and handle all your financial matters for you. And if the durable power of attorney is done correctly, crossing the T's, dotting the I's, giving you all those elder law powers in that legal instrument, is designed with the objective of avoiding expensive conservatorship proceedings at the probate court. And then, folks, you're the expert in the family. You want to think about who would be a suitable backup, who would be a suitable successor or alternate attorney in fact. Maybe it's your child, maybe it's your son, maybe it's your daughter, maybe it's a good friend, could be a sibling. So think about that. And you want to put your number one backup pick right there. You want to put your Tom Brady, so to speak, someone who you feel is most suitable, who you trust unconditionally. And if either you or Mary, both of you are completely incapacitated, who would be your backup? You know, would it be your son? Would it be your daughter? And then it's always prudent to pick a third as well. If you have that person on your family team, your team, okay? Bill and Mary's team. They pick their Tom Brady, their son or daughter, as their first successor, and then they pick a backup successor to them, okay? And I typically recommend do not pick two of the same, because that could create a conflict if they have a disagreement. You don't want conflict or tension or disagreements at this juncture if either of you are completely incapacitated. So recommendation, pick your number one pick after the spouses, and then a backup if you have it. Okay, folks? Really, really important. Again, this is to manage finances to avoid expensive conservatorship proceedings at the probate court. I'll share a brief story with you. Had a case several years ago, no names, of course. My dear client, wonderful gentleman, married to his bride about 50 years at the time. Sadly, his wife never signed a power of attorney, never signed a healthcare proxy. Sadly, she was diagnosed with severe dementia in her late 60s. The husband of 50 years had no legal powers, no legal authority to move his wife from the hospital to a nursing home. The medical providers at the hospital said, "Sir, sorry, you don't have any legal right to do this despite your 50-year marriage. You need to hire your estate elder law attorney. You need to retain counsel, and you need to petition the probate court first and foremost to become appointed as legal guardian for your incapacitated wife so you can move her from one facility A to facility B." So we had to petition the probate court. The meter's running by the hour. And then the other part of this was he had to manage an asset because he had a private pay, the nursing home, $15,000 per month. He didn't have the money to do it, so he had to sell a second property. His wife is on the deed to the property with the husband. Could the husband pick up a pen and sign his wife's name on that deed? Absolutely not. Not until he was appointed by the good judge as her legal conservator, which is a second office or a second hat that he has to petition the probate court for and then be approved. And that's an arduous, lengthy process. And in the probate court here in the Commonwealth of Massachusetts, the probate court rules C, when there's an incapacitated individual, the probate court judge needs to appoint what they call a guardian ad litem down here. They call it a GAL. And that's typically a private attorney on the court list that the judge or the judge's clerk picks. Attorney so-and-so, you're going to serve as the incapacitated person's guardian ad litem. And guess what, folks? They are not free. They charge by the hour, and they're going to charge the estate. So now my poor client, he's paying my Elder Law Care Center by the hour for these 2 probate court proceedings, right? By the hour, meter running. Now the probate court is appointing a guardian ad litem, and he's paying that guardian ad litem as well. So he's paying 2 attorneys at this juncture. Then sadly, it gets worse. The court sees that his dear wife is incapacitated, so the probate court rules require that another court-appointed attorney be appointed called a Rogers attorney. And a Rogers attorney is required when an incapacitated person is receiving antipsychotic medications, which is a very common medical protocol for folks with dementia, sadly. And when the probate court sees that on the paperwork, it automatically triggers a Rogers attorney being appointed as well. 3 attorneys now. Who's paying for the Rogers attorney? Yes, the husband. Who's paying for the guardian ad litem? Yes, the husband. Who's paying for us to petition the probate court and go through this arduous process? Yes, the husband. Time's free. He's paying 3 attorneys by the hour, and this process can take months and months and months because these court-appointed attorneys need to investigate the family. They need to speak with the doctors, draft up these comprehensive reports, submit them to the probate court for the good judge, who are very busy people, time to review and make a decision. And it's not free, folks. So I share that story with folks that attend our educational program to impress upon you the critical nature of the Big 6 disability planning. About 6 months into that arduous, expensive probate court process, my client said to me when we're getting him appointed as legal conservator for his dear wife, he says he was exhausted and exasperated. He said, "Hey, Patrick, you mean to tell me if so-and-so," referring to his bride, "had just signed a power of attorney and a healthcare proxy, we would not be here today at probate court?" And the answer was a resounding yes, yes, yes. So yes, folks, you need these guys right here. This is the metaphorical sword and shield that slays that metaphorical first-headed monster, which we refer to probate court. And the probate court here we're referring to is disability probate. When you or a loved one becomes completely incapacitated or disabled, like in our client's wife's situation with severe dementia. She had nothing in place. Her husband had to go through this arduous process. Hence the reason why I coined it in my book, Messes and Stresses of Probate Court and the Economic and Emotional Headaches of Probate Court, based on my professional experience representing my client and watching him go through this unfortunate process. So folks, this right here, you need to create this when you are alive and well. Do not wait till you're alive and not so well. Alive and well. 3rd quarter of life. 3rd quarter of life is when you create this. No later. Do not wait for the fourth quarter. Do not wait for the 2-minute warning, because folks, from our experience, if we wait till the 2-minute warning, like in this case right here, typically time runs out because his wife could not legally sign legal instruments, power of attorney, healthcare proxy, because the legal standard is she needs to possess what they call testamentary capacity. And if someone's diagnosed with severe dementia, they do not have testamentary capacity or sufficient testamentary capacity. The elder law industry standard is mild dementia, maybe they can sign. They should be able to sign. It's like a lavalier. They have sufficient capacity to sign a will, a trust, or a durable power of attorney. They're all high standards. You need to have capacity. You need to know what you're signing in the presence of a notary, right? Notary public. And in this case here, it was not mild, it was not moderate, it was severe dementia. His wife did not have legal capacity, so legally, a notary could not notarize any legal instruments for her. They had no choice but to petition the probate court. And that's why you're taking this course. That's why you're receiving this education, folks, so you can slay that metaphorical first-headed monster, disability probate, by getting your power tools, the Big Six disability planning, in place when you are alive and well. Numero uno, durable power of attorney. We refer to this right here, 60 and over. Please work with an experienced elder law attorney, because you will need what we call enhanced elder law powers, enhanced elder law powers in these instruments. Not the standard fare 5-page durable power of attorney. In fact, folks, I call ours the kitchen sink provision. It's about 26 pages for a reason, because you want as many powers in your durable power of attorney instrument or tool as possible, because if the power is typically not in there, your attorney, in fact, agent will not be able to do that function, that task for you, whether it's a bank or a financial institution, and they're going to say, sorry, you need to go to probate court and petition the judge to get that enhanced power. So nip it in the bud. Strong recommendation, get all the powers in there. I call it the kitchen sink provision. You want all these important germane powers in there. And every state's a little bit different, so work with an experienced elder law attorney in your state, in your jurisdiction. Okay? So that's numero uno right there, folks. And again, this is a recap. Power of attorney to avoid conservatorships at the probate court. Slay that beast.